When do we deserve them? Now! You are exactly like Adolf Hitler. Can't you see that?
Over the past 2 decades, the right to marry has provoked a firestorm of controversy when it involves the issue of same-sex marriage.
Shame on him! Shame on you!
The battleground for this debate has moved from state courts to state legislatures, and now to the U.S. Congress, turning what was an individual state issue into a federal issue. While advocates say they are merely seeking equal rights under the law, opponents contend that marriage should only be allowed between a man and a woman.
One of the great advantages of federalism people talk about is that states are laboratories for experiments of different types of policy. And so many people claim that as we're moving into this new area of trying to understand whether or not gay marriage would be something acceptable in the United States, that it makes some sense to have certain states that are willing to do it as laboratories of experimentation, and that one size fits all is not a particularly good standard for something that is so controversial in the nation.
Traditionally, marriage has been a policy area reserved for the states, but the full faith and credit clause of the U.S. Constitution requires every state to recognize the public acts and judiciary procedures of every other state.
If, for example, one state legalizes gay marriage and a couple is seen as a legitimately married couple in one state, and they move to another state, must the state treat them as a married couple and give full faith and credit to the decision to allow them to marry in another state?
The debate among federal and state governments over same-sex marriage reached critical mass in 1996 when the Hawaii Supreme Court ruled in the case of Bear versus Lewin that the state constitution established a right for same-sex couples to marry.
The Bear case in Hawaii was the first case to recognize that the restriction of allowing same-sex couples to marry was discrimination on the basis of sex, not sexual orientation per se, but on the basis of sex, meaning that I, as a woman, cannot marry another woman, but if I were a man, I could marry that woman. So it used that argument, which ultimately was the argument that Massachusetts used in order to pass gay marriage in that state.
While the Bear decision was ultimately reversed by an amendment to the Hawaii Constitution, Congress was quick to redefine marriage.
No one state of the Union can have its decision of its people overridden, run roughshod by people judges from another state.
Anticipating that other state courts might also condone same-sex marriages, Congress passed the Defense of Marriage Act in 1996.
It defined marriage as being a relationship between a single man and a single woman. And in the same act, Congress suggested that states need not accept another state's definition of marriage as a way of governing how they treated people in their own state. Some people claim that that latter part, at least, violates the full faith and credit clause of the Constitution.
Social relationships, personal relationships, if they're defined by government at all, ought to be defined by the state government under our concept of federalism, not the federal government.
The growing collision of state and federal regulations raised an important constitutional question. Are federal and state laws that extend marriage rights only to individuals in heterosexual relationships constitutionally vulnerable because they lead to unequal treatment of individuals in same-sex relationships? In a landmark 1967 case, the Supreme Court struck down state laws that would not recognize interracial marriage.
The case of Loving versus Virginia, which struck down any laws that would not recognize interracial relationships, is not the exact issue that is at play here, but it certainly provides some very useful parallels when it comes to the argument of same-sex marriage. First and foremost, the Supreme Court recognized that marriage is a fundamental basic civil right that is afforded to individuals and is not subject to the state to decide.
Marriage has everything to do with the bringing together of the sexes. It has nothing to do with race. The point is, there is a reason it is one man and one woman, and there are some special things that happen in that committed relationship that are good for children, that are good for society.
What's very telling is that the same arguments that were made against interracial marriage are the same arguments that are being used against gay marriage, and that it's not God's will and that it has an adverse effect on family and children. The role of the courts traditionally has been to protect minority rights over the majority will.
Join me.
Join me.
Be wise.
Be informed.
And right now, with the gay marriage issue, we have a lot of this going to a vote.
We're all Californians. We're all equal. Let's keep it that way. Vote no on Prop 8.
Gay marriage will be taught in our schools unless we vote yes on Proposition 8.
It would be interesting to see how interracial marriages would have fared as part of a popular vote if it had been put up to the people at that time. And it is counter to our system to have the majority be able to vote on the rights of minorities.
But the Supreme Court has been hesitant to extend equal protection guarantees to marriage laws that discriminate on the basis of sexual orientation.
I would say that every citizen should have full protection under the law, but you get into a problem when you start creating special protections for people based upon their preferences or their lifestyle. Then you begin elevating that over other people. An example would be, a law that gave special protection to people based upon sexual orientation.
If we're to prevent the meaning of marriage from being changed forever, our nation must enact a constitutional amendment to protect marriage in America.
Once again, seeking to preempt state laws and judicial extension of marriage rights to same-sex couples, Congress proposed the Federal Marriage Amendment in 2004. If ratified, the constitutional amendment would have limited marriage in the United States to unions of one man and one woman.
It would actually allow the people to be a part of that decision. What's been happening over the past years is the homosexual activist attorneys, they knew they could not win any vote in any of the states. So the idea was go into the state courts, more liberal state courts, win a lawsuit, then force same-sex marriage on that state through the court, then have people from other states fly there, get married, go to other states and say under the full faith and credit clause of the United States Constitution, you have to recognize our marriage. And by doing that, they could force this new definition on society, really without anybody getting to vote on it.
Those who are proponents of gay marriage are not arguing that there needs to be, at a federal level, a definition of marriage. What they're saying is that from state to state, there should not be discriminatory laws that do not allow for the equal treatment of individuals, in this case, same-sex couples. So the idea of enshrining discrimination into our Constitution is very counter to our whole system of government, which is one of the reasons the Federal Marriage Amendment failed.
Marriage is a core institution in American society, but will it be defined by the federal government or by the states? For some, it is to be protected and defined as a union only between a man and a woman.
Homosexuals, lesbians, bisexuals have the freedom to be in whatever relationship they want to, but they don't have the freedom to redefine marriage for society because it has consequences. Really, it doesn't just redefine marriages, it destroys the definition, because there really is no tenable definition after you unhinge it from the distinctiveness of the sexes and bringing one male and one female together.
For others, marriage provides the legal benefits and privileges that should be guaranteed to any couple under the law.
It is about equality. It is about inheritance rights. It's about health insurance, about Social Security. It's about not being discriminated at work. It is about being able to make medical decisions and inherit property and be able to have hospital visitation to your partner. But at the core, it's something so much simpler and greater than that. And it's the basic human need to be loved and to be able to create a family.